I welcome you to this virtual launch of the Commission's report on accessibility of legislation in the digital age. Fáilte. The project which has resulted in this report is Project 11 of the Commission's fourth programme of law reform. When the programme was first published, the title to the project was Codification, Consolidation, Simplification of the Law. It is interesting to note that in the abstract on the project, there were a number of references to consolidation and codification of legislation, and relatively little focus on a digital approach to making legislation more accessible. Although the abstract did refer to the work of the e-legislation group under the auspices of the Department of the Taoiseach, and to the introduction of technological tools such as legislation workbench, the legislation workbench. However, when the issues paper on the project was published in 2016, its title, which I consider more realistically reflected the Commission's task, was Accessibility, Consolidation and Online Publication of Legislation. As the use of ICT in relation to legislation has been developing over the 4 years since the issues paper was published, the title to the report, which is now being launched, which the Commission considered would be more informative of its task, is Accessibility of Legislation in the Digital Age. Indeed, our consideration of that proposed title before the lockdown 6 months ago seems to me to have been prescient, given that work-wise we are now in a largely digital age. My role today, the easy job, if I may call it that, is twofold. First, it is to draw your attention to the report itself, but more importantly, to draw your attention and to express the Commissioner's gratitude to those who made its publication possible. As is acknowledged in the report, the Commission received valuable assistance from consultees, both through written submissions received following the publication of the issues paper and also through discussions which took place with the Commission. I reiterate the Commission's gratitude for that assistance and emphasise once again the importance of the work of the Commission and in particular the importance of consultation in that work. That's consultation with the public generally and in particular with stakeholders. The principal legal researchers for the project were Owen Garvey, who is now even closer to the legislative process than he was when he worked as a researcher here with the Commission, in that he is now a parliamentary legal advisor in the Houses of the Oireachtas. And the second principal legal researcher was Suzanne Scott, who took over from Owen in 2017 and was thereafter effectively the principal author of the report, and who I am very glad to say is still with us. Both researchers made enormous contributions to the production of the report. The same can be said for our full-time Commissioner, Raymond Byrne, who has been the coordinating Commissioner for the report. To Owen, Suzanne and Raymond, and indeed to all the personnel in the Commission who have been involved in the production of the report, in particular the Director of Research, Rebecca Cohen, I express sincere thanks on behalf of the Commission. Likewise, I express sincere thanks to the personnel in administration who have had no easy task in getting this report both online and in print form and ready for launch today. My second role is to introduce you to the presentation by Commissioner Byrne on the report, in which he will explain the content and substance of the report and will outline the key recommendations of the Commission in the report. Before I hand over to Commissioner Byrne, I express the hope that this report will guide and assist our legislators with the assistance of the government and the Attorney-General to provide the public, in plain language, with speedier and easier access to our laws. Commissioner Byrne will now do the hard job and will tell you about what is in the report. However, before that, let me, a self-characterised, involuntary, and I stress involuntary, Luddite, say, buíochas to Zoom. Thank you.
Thank you, President. The report that we're publishing today looks at a number of issues relating to the accessibility of legislation, especially in this digital age. And what the report does, first of all, is that it identifies many of the important improvements that have been made to making our legislation more accessible, particularly online and free at the point of delivery. And those developments have included the reality that the electronic Irish statute book, which is hosted by the Office of the Attorney General, has become the main source for most people of access to the full text of legislation. And other developments that are very important in recent years have included the fact that the Houses of the Oireachtas have also very much improved the accessibility of legislative information, going back all the way to the foundation of the state. In addition, the Law Reform Commission itself has been very much involved, particularly over the last 15 years, in contributing to the accessibility of legislation in a number of different ways. That has included the development of revised acts, which are acts in their amended form, now running to over 380 revised acts. Another development that the Commission has been involved with is the Legislation Directory, which tracks all amendments to legislation, all of the in-force legislation in particular, enacted since the foundation of the state in 1922, and also the acts that have been retained from before 1922. The Commission has also developed a classified list of in-force legislation, which provides a database on our website in relation to accessibility of legislation. So all of these developments are incredibly important and have made legislation more accessible, particularly in the online environment. And what the report being published today is really trying to do is to build on those developments and to make proposals as to how we might make our legislation more accessible. Accessible in that online sense. So what we're really looking at then are a couple of very important and fundamental principles that underlie the report. One is that in a country governed by the rule of law, where the rule of law is taken seriously, it's incredibly important that our laws be accessible to citizens and to businesses so that people actually know what the law is and can therefore comply with the law. The other aspect of this is arguably an economic argument, that if the law is easier to access and be accessible, then the cost of doing business in the widest possible sense, both for businesses, but also for those who in the public service have to enforce the law, rely on ensuring that they can see the updated version of the law. Again, these are costs to the state of doing business. So the more that legislation is accessible, the more the rule of law and all of the fundamental principles that a state is based on can be assured. So that is really the background to the report. The other aspect to bear in mind is that in terms of a modern state, the amount of legislation that is actually in place has grown enormously over the last number of years, in particular since the turn of the century. So the 21st century has really seen an explosion of legislation covering all kinds of areas of our lives. And in fact, this is reflected also in the position at international law level, on which the Commission recently published a discussion paper on our international law obligations and the impact that they have had. So the report today carries on that basis of making our laws as accessible as possible, bearing in mind that there are over 3,000 in force pieces of legislation that we call acts, or primary legislation, over 3,000 of those that are still in force. Many of them predate the foundation of the state, but they're also available on the Electronic Irish Statute Book. So trying to bring those all together and to make them as accessible as possible is certainly a significant challenge. And what we're proposing in the report today are a number of steps that we could put in place in order to further enhance the accessibility of legislation. The first major proposal in the report is that we should engage in a planned programme of consolidation of legislation. Now, consolidating legislation means bringing together the rules in a particular area under one roof, if you like, or one piece of legislation. And this has been done on a number of occasions. For example, in the Social Welfare Consolidation Act, the Companies Act, and the Land and Conveyancing Act. These are all major pieces of legislation enacted in recent years, which bring together all of the law in those very important areas. So that has already been done, but it hasn't been done in a planned, programmed way. And that's what we are proposing in the report, that this be done on a structured basis, that a program of consolidating legislation should be put in place. And we made some suggestions as to what might be initially looked at in such a planned program of consolidation. For example, in the area of the law on road traffic, the main law in this goes back to 1961, and that has been amended many, many times. And there have been a number of occasions in which the courts have said that the law in this area, even for courts and lawyers who are used to looking at amended legislation, that is very difficult to actually see what the law is at any given time. So we've suggested that as one of the areas that might be looked at in terms of an initial program of consolidation. So that is our first major proposal. Our second proposal would be that the Commission itself would continue to develop programs of consolidation in their amended form, that is, revised acts. And the Commission has in the past put together programs of revised acts, and we suggest that we would continue to do that in conjunction with the programs of consolidation. And what we suggest is that in order for this to be planned in a structured way, that a multi-agency body should be established, which we have said could be called the Accessibility and Consolidation of Legislation Group, the ACLG. And that group would bring together all of the interested parties and professionals who have an interest in legislation and the design of legislation, and who have, for example, worked on the improvements that I've already described. So that would include the Office of the Attorney General, the Office of Parliamentary Counsel to the Government within the Office of the Attorney General, the Houses of the Oireachtas, including the Parliamentary Legal Advisors and the Bills Office, the Law Reform Commission itself, those who have an interest from government departments in legislation, and also policy experts. And I think that's quite important to place the proposals that we're making in the wider context of regulatory reform and the proposals that have been developed over the years in terms of regulatory reform generally, which have included reform in the legislation area. And that also fits in with wider government policy on digital by design. So the proposals that we're making here are really also linked into that overall government policy and perspective on regulation and better regulation, and also in terms of the ongoing development of digital, which particularly this year, I suppose, people have been particularly conscious of with the COVID-19 pandemic. So in addition to those two main proposals on consolidation and revised acts, which would be coordinated by this multi-agency group. It would be a coordination group at bringing together expertise. In addition, that group would also look at legislation in its online and digital sense, if you like, an e-legislation aspect. And we propose that this group also develop an e-legislation strategy in order to bring together all the different components in an end-to-end approach to the production, the enactment, and the post-legislative review of our legislation, and looking at that from making the best use of information and communications technology. So from that point of view, we propose that that overall strategy and proposals on consolidation and revised acts would become part of the overall proposals that would emerge and guidance that would emerge from our proposed accessibility and consolidation of legislation group. And amongst the issues that they would look at, that we suggest, would be to examine the question of the online status of legislation. And in fact, we propose that if possible, legislation should be enacted to provide semi-official status to the online publication of legislation. This would be consistent with the approach that's taken in a lot of other countries which have moved towards making their online version, as opposed to the printed version of legislation, make the online version the semi-official version. This has happened in most European countries, and in fact at EU level, the official version of EU law is now the version that you would find on the website of what's called the Official Journal of the European Union. So that version that you see online in terms of EU legislation, such as the General Data Protection Regulation, the GDPR, that is the official version. And that official version is given a guarantee in terms of a certified electronic certificate, which once it is attached to that piece of legislation, guarantees the integrity of that legislation. So we say that that model should also be followed in any proposal to make online legislation the semi-official version. So those are some of the proposals that the Commission has put forward in the report published today. There are a lot of other elements involved in those detailed recommendations, but the key issue and the key approach that we've taken in terms of the proposals is to make further improvements, to build on the existing developments that have actually come about in recent years in terms of making our legislation more accessible, in terms of ensuring that it is available online, and from that point of view to build on those developments and to provide a structured basis using this multi-agency body in order to bring together all of the ideas that those involved in the making and production of legislation have already developed, and to put that together in a structured basis so that into the medium term we would have an even more accessible form of law so that we can comply with those very fundamental principles that I mentioned at the beginning on the rule of law, and also facilitate more efficient and cost benefit of doing business, both for the private sector and for the public sector.